Hi guys, and welcome to my channel. My name is Romanov, and I'm a family law specialist practicing family law in San Francisco. This video is informational only and doesn't constitute any legal advice. Let's jump right into it. Today I would like to talk about 5 common myths about divorces. Some people come to my office and they say, well, if I file the divorce this year, I can get my single status and I can get I get divorced and I can get my single status for that year. Well, it's not true. Even if you file for divorce in this year, let's say December, it has to be 6 months and 1 day before the single status can be even asked for. So that means, let's say we're today in 2018, December, if someone filed for divorce in 2018, only in 2019, assuming that the divorce would be final or the status terminated, that way the person who is filing could ask for single status or the other spouse as well. The second myth, if I file for annulment within 2 years, that means I can get my annulment done and I will be pretending like the marriage never happened. This is not true either. The annulment can be filed at any time. It's getting harder the longer you wait because if you live with your spouse, it could be assumed that you accepted, let's say the reason was fraud, you accepted the fact that the spouse deceived you at the time when you were getting married. For example, if the spouse was only marrying you for green card, but then you stay in the marriage and keep living together in the same place and have a romantic relationship, then it's becoming difficult. However, if the sooner you file, the better. And it doesn't, even if you file for annulment, it's not automatically going to be dissolved unless the other spouse agrees to the annulment. There will be a so-called evidentiary hearing necessary where the judge would hear your arguments about the annulment and then decide whether or not annulment is an appropriate course of action. And sometimes a trial is required when the other spouse says, I feel deceived, and the spouse who files for divorce says, I feel deceived, you just wanted a green card, and the responding spouse says, well, actually we live together and I thought it was real marriage. Yes, I got a green card through this marriage, however, I thought it was a real marriage. And then the judge hears both parties' arguments and then decides whether or not this was a proper annulment. So nothing is automatic. The third myth that I hear often is, if we file for summary dissolution, our divorce would be final sooner than anything else. Well, first of all, it's not true. The 6 months and 1 day applies to both divorce and summary dissolution. For some of you who don't know what summary dissolution means, it's when both parties were married less than 5 years and neither party is asking for spousal support and each party doesn't have more than $40,000 in assets nor $40,000 in debt. That means summary dissolution could be an appropriate action which requires less paperwork. It would mean that both of you will sign one form and file it with the court versus each party signs one form and file it with the court, and less paperwork, meaning the judgment itself is way shorter. But the time frame remains the same, 6 months and 1 day from the time both parties file summary dissolution. The fourth and very interesting myth that I heard many times and still heard to this day, if my spouse was unfaithful, then I can get more spousal support. I can get more spousal support or alimony or properties. It's not true. California is not a fault state, so it doesn't matter if your spouse was unfaithful or not. It's irrelevant. The most common reason for California is so-called irreconcilable differences, which means that both parties don't get along. They just don't get along, that's it. So you don't have to have any explanation why, no emotionality around it anymore. No dirty laundries will be washed in courthouses anymore, which is pretty good. I like that change. And the final myth is, after 6 months and 1 day from filing for divorce, I can be single automatically. Well, a lot of assumptions have been made about whether or not things happen automatically, but what I found in family court, nothing happens automatically unless you ask for it. So after 6 months and 1 day, usually I would suggest a month before that 6 months and 1 day from filing and serving the other spouse with the petition for dissolution, I would say a month before, let's say after 5 months, I would tell my client to file a request for order to ask for bifurcation status only, translated in English, terminate the marital status only, even if other issues are not resolved. So the other issues such as spousal support, property division, custody can be put aside and reserved for later resolution. The California law supports a quicker resolution of divorce, and that will help emotionally to disattach. So when both parties know, okay, we're no longer married, and let's figure out the rest of our discrepancies about financials or custody issues, then it's sometimes easier to move forward. Or let's say another spouse wants to get married, so there could be any other reason. And again, it would be decided by the court. There are 2 requirements to get single status only. First requirement would be that the moving party would have to serve the other party so-called preliminary declaration of disclosure, which means all of the financial disclosures such as assets and debt form filled out with attachment, income and expense declaration form with attachments. That's number 1 requirement. And the second requirement is the retirement type that both parties have don't require a joinder, which I will be talking about in a different video. This is supposed to be a very short video to bust all of the common, at least 5 most common myths about the divorce. I hope it helped, and if you liked the video, please click like, and I will see you soon. Bye!